I've blogged about this and talked about this issue before, is I think that for an IT company, its end user agreements are too important to be left only to the lawyers. So let me explain this a little bit. Is if you really think about it, your end user contracts or channel agreements are part of the way you sell your technology, part of the way you license it, part of the way you go to market. So you need to think about what they're saying about your company. And so don't just leave them to your lawyers and take whatever they give you and they say, hey, that's the way it is and this is what you need. Really think about what you need, what's important to your company, what clauses you need, what clauses can be reciprocal, what need to be one-sided. So I really inspire and try to inspire companies to take ownership of these agreements and to really have at least one person that knows what's in them, what's not, and if anything needs to be changed, then they know how to make those changes and what changes they're okay with. This should be something that the company owns. In the tangible world, I think that contracts aren't as important, but in the IT world, they're much, much more important. They set the stage of what your customers and resellers can and can't do with your technology. So take ownership of them, think about what needs to be in them, and debate it with your attorney and try to get to the right place for your company, because I found there really is no one size fits all. A contract works for one IT company and it really works for another. They're very unique attributes I found to so many IT companies. So think about those, take ownership of it, and it's really, really important. And the sooner you do that, I think you're going to reap the benefits of, number one, having a contract that's consistent with your model, and number two, also setting the right expectations and risk in terms of what your customers can and can't do with your product. So really take a read before your customer does.